Human behavior is really odd. It's somewhat unpredictable. People often act on a whim. They do strange things, they do crazy things, and they're surprised afterwards at what they did. Nevertheless, we can sometimes predict what people do. We can to some extent explain why people do what they do. We can think about what we did and explain why we did what we did. Even though it is difficult to explain and understand human behavior, we have to do so, particularly if those humans are political decision makers, particularly in a democracy. Under the legal model, justices' decisions are explained as the result of legal rules and legal reasoning. So what the justices do is simply the result of what the law tells them to do. Other factors, the justices' own personal opinions, their attitudes towards political issues, their own self-interest, make no difference, only the law matters. So that's the idea of the legal model as an explanation of what justices and judges in the lower courts do. So there are several types of legal rules and types of legal reasoning, and let me quickly go through those and explain how they can be used to explain why justices make their decisions. First, there is precedent. Then there is the text of the law that justices may follow. Then there is the intent of the lawmakers or framers that the justices may follow. When we talk about statutes, which are laws passed by a legislature with simple majorities typically, we talk about lawmakers. When we talk about a constitution, such as the United States Constitution, however, we talk about the framers. Finally, there is an approach to legal reasoning that looks at the broader purpose of the law. Let's take a closer look at all of these different types of legal rules and reasoning in detail. Okay. Precedent works the following way. Let's say there is an old Supreme Court case decided years ago, maybe decades ago, and the Supreme Court decides a new case that's somewhat similar to the old case. This means that the facts of both cases are similar in important ways. What happened in the dispute that the court has to decide basically is similar in important ways. Also, the legal question is either the same or very similar in both cases. If that's true, then if the court follows precedent, it uses the legal rule used to decide the old case and applies it to the new case and uses it to make the decision. Okay? Now that's what the Supreme Court is supposed to do. The Supreme Court is supposed to follow precedent, its old legal decisions in cases that are similar to current cases. But you may remember that Justice Scalia indicated that it's possible that justices decide that the old case was wrongly decided and therefore they don't follow precedent. So there are always exceptions to the rule. Here's an example of how one can use precedent. Let's say we want to interpret the Privileges or Immunities Clause of the 14th Amendment. Then we can take a look at the slaughterhouse cases of 1873 and ask, how did these cases define the Privileges or Immunities Clause? What did they say privileges or immunities means? By the way, we'll take a closer look at the slaughterhouse cases next week. Second, the text of the law is an important legal rule that justices often use and are supposed to use. There are two ways to deal with the text of the law. First, there is just the plain meaning. You read the text of the law, the part of the Constitution that you interpret and imply, and you just use what you understand from the plain text. A more sophisticated approach looks at original public meaning. The question is, how did the general public, when the law was passed, understand the text of the law? So, for example, when a constitutional amendment was ratified, how did the people understand the words in that constitutional amendment. So when we go back to the example of the 14th Amendment, we would ask, what did people in 1868, when the 14th Amendment was ratified, understand under privileges and immunities? This was a phrase that was used in political discourse. Let's investigate, do some historical research to understand how people understood this phrase. Okay, a slightly different approach is to look at the intent of the framers. What did the framers have in mind when they passed the law? What did they want with the law? The framers in particular, when we talk about the Constitution, are the ones who actually drafted the Constitution or constitutional amendment. So in the example of the 14th Amendment, Congress in 1866 drafted the 14th Amendment, and we would have to ask, what did Congress want to achieve when it passed the 14th Amendment? What did the people think who actually wrote the 14th Amendment, who debated it, who voted on it? Okay? Finally, there is the purpose of the law, and that's similar but slightly different from the intent. The question we have to ask for this approach is, what was the general social values expressed by the law? What were the general social values? Sorry, there's an error here on the slide. And how can these values be attained under today's circumstances? So you see two things. First of all, the question is about the general values that are included in the law, not by the subjective goals of the people who passed the law. Okay? Second, it's about applying the law to different circumstances. And that's something that the intent approach does not look at. The intent approach simply asks, what did the people who wrote the law want with the law? And if the circumstances differ from what they wanted the law to be for, we cannot apply the law. Under the purpose approach, we can still apply the law because we don't ask about what the framers wanted or the people who passed the law. We are interested in the overall values that are expressed by the law, whether the framers actually intended to pursue these values or not. Okay? Now the example is, what social values were included in the 14th Amendment? What did the 14th Amendment express? And what court decisions would best realize these values? So the 14th Amendment, for example, can be argued to express the value of equality. Equal protection of the law is in there. The value of citizenship rights, privileges or immunities. And we can think about different circumstances that the framers of the 14th Amendment didn't think about when they passed the 14th Amendment. Racial desegregation of public schools, that's something that many of the framers of the 14th Amendment were actually in favor of. Or same-sex marriage. Equality in terms of sexual orientation, that's clearly something the framers of the 14th Amendment didn't think about. But you can make the argument that equality is one of the values in the 14th Amendment, and there are ways to realize this value in ways that the framers of the 14th Amendment didn't really think about. Okay, so what are the advantages of using these different types of legal rules and ways to interpret the law to explain, to predict, to describe the causes of justices and also lower court judges' decision-making? One advantage is that generally it reflects how many people want the courts to act. You know, many people want the courts just to interpret and apply the law, and that's essentially what the legal model says they do. In addition, the legal model reflects the way judges and justices think. If you ask people like Justice Scalia or Justice Kagan or some of the other justices that you recently watched interviews with, they will explain that they make decisions based on the factors that I just explained, right? The text of the law, precedent, intent of the framers, and stuff like that. Okay, now what are the disadvantages? What are the problems? Well, if you go through those 4 different ways to interpret the law, and there are some more, you can basically justify any decision that you can think of, in many cases at least. And that's a problem because this means that we cannot really empirically test the legal model. It's not falsifiable. We cannot think of circumstances where somebody could go against the legal model and we observe it. So that's a problem if we want to use the legal model as a general explanation of why justices make the decisions they do. It's not the scientific theory, in other words. Now, in some circumstances, one can test actually the legal model, and that result didn't look too good for the legal model either. So, for example, we could say that justices who disagree with a court decision will follow this court decision once it has become a settled precedent. That's what the precedent rule of the legal model says. The justices have to follow precedent, even if they disagree with it. So one famous example is Roe versus Wade. That's a precedent that was created in 1973, and it created the right to have an abortion. Women have this right during the first 6 months of their pregnancy, basically. And there were two dissenters. One was Justice Rehnquist, and you see the color portrait of him here, and Justice White, the black and white portrait is him. Okay, so Roe versus Wade became a precedent, and about 10 years later there was a follow-up case, Akron versus Akron Center for Reproductive Health. And it was about restrictions on abortion imposed by the city of Akron, and Akron Center for Reproductive Health was an abortion provider who sued against this, because the Akron Center said the restrictions on abortion basically run us out of business, and it's just a hidden way to restrict abortion in an unconstitutional way. And the court majority agreed with the Akron Center. It said, we use Roe versus Wade as a precedent, applied to the current case, it's very similar to Roe versus Wade, and we uphold the right of women to have an abortion during the first 6 weeks of their pregnancy. Now, what's an interesting test here is, how did Justices Rehnquist and White decide? According to the legal model, they should join the majority now, because now Roe versus Wade is settled precedent, and under the legal model, justices should follow precedent. However, Rehnquist and White dissented again. Okay, they did not follow precedent. So that would be evidence that goes against the legal model. Let me summarize. The legal model is a good rule for how judges and justices should make their decisions. I think everybody agrees that justices and judges should apply legal rules in their legal decisions. The legal model is also a good description of how judges and justices think about what they do and how they argue about cases. However, the legal model is a bad description of how judges and justices actually behave.